Can you Melissa, for my own notification, I don't know about any others, but when you said child abuse registry, be a little more specific of what it was when it was in existence prior to 98?
Yes. So there are every state has repositories of information about families and children. And states are not required to have a centralized registry, but many states do, the majority of states do. And again, Georgia did prior to 1998, and it was an information system that predates our Shines that you all have now heard about. But at the time, that was kind of the thing. It was long before there were statewide information systems for child welfare. And again, the whole point was when you were the subject of an investigation, regardless of the outcome of that investigation, whether it was substantiated or not, your name was entered into this registry. And there was information about the identity of the child, the identity of the parents, the identity of siblings, the identification of the actual perpetrator, so if it was dad or boyfriend, etc. Also information about the findings of that investigation. And again, so that information was just stored, and then employers like schools or early care and learning before it became its own agency, but those kinds of things could ask for registry checks. Other state child welfare agencies can also ask for those registry checks where they exist in states when they have families cross state lines. So in that way it's useful. But and then when there are subsequent reports about that family, they run checks as part of the same checks that they look into, does this family have criminal history? All that kind of assessment early on about how to triage this case or this report into a case. And again, there was a facial challenge to it as that statute applied. There are procedures that always accompany that registry about how you would go about appealing the fact that your name is on that registry, how would you go about getting your name expunged if it was erroneous. And what happened in the case in 1998 was there was a man who was accused, I think there were 5 or 6 counts of child abuse, and they were also linked to criminal charges that he was facing. He was exonerated on the criminal charges, but his name still remained on the registry because it's a different legal standard. And the Supreme Court of the state decided that was unconstitutional because of the implications for his liberty interests in doing a number of things. And so that was where we stood. So there are the challenge in resurrecting it is that the Supreme Court's ruling on this really eviscerated the entire thing. They didn't really leave us much to go by way of repairing the statute because they sort of took it down at every level. And so, what they did point to were the specific deficiencies in our statute that they found constitutionally infirm. And so that's kind of at least a starting point of knowing what would be required to have a registry that might pass constitutional muster.
But Melissa, it's my understanding if the registry included only substantiated cases, right?
That's, so the safest bet, the most conservative approach would be to have it only contain cases where people have been criminally convicted.
Well, see, that's the issue because child abuse is a civil.
That's right.
Unless it's chosen to be prosecuted criminally.
And very few cases are.
Right.
But the reason that that's the safest bet legally is because you have a full and fair hearing that goes along with all that criminal conviction and full rights of appeal, and that was part of the deficiency of our registry. The second level would be to include substantiated cases, because those two have a kind of fuller vetting, if you will, that meet some of these procedural protections that aren't available otherwise. Those are choices we'll have to make, I think, in some ways if this goes forward. And we'll just have to you just kind of test it, knowing that we may not survive another challenge, but we can try.
Just the best practice kind of and models from, because the majority of states have a registry.
36 states have registries.
Right. So obviously there's got to be best practices and models to protect, folks in the 36 other states.
Yeah.
So my question is, which subcommittee should take that part on?
So what we had talked about, and I know Melissa is obviously a subject matter expert on this, but what we had talked about was Bobby actually stopping by Chairman Willard's committee and talking through this issue with you, Chairman, and seeing if it's something the committee wanted, it's something the committee was interested in exploring and talking further about the issues that Melissa's just gone through.
And I think this is a prime example of where PR comes in handy, because the issue right now is that you could hire a worker for a high quality child care setting and inadvertently hire somebody who has physically abused children, and because it was a civil case, that you have no access to that information. So, and I think if the majority of people understood that, they would not be happy about it, particularly parents.
I can just give you a very practical example that I called Bobby on because obviously he's been at DeKalb and then was at DFACS, but we had to do an emergency closure. We've actually had to do 3 emergency closures in child care centers this summer, unfortunately. And the legislature, those who are here, recently passed legislation allowing us to do that when there was a concern regarding child safety, and it's when we've had a child death or a child who was seriously injured. And I called Bobby to say, you know, did this person have any history with DFACS? The person was a parent, and so I was curious, and he said, well, we don't know, and the reason we don't know, and that's how, you know, we got into this. And so it has really, you know, very real implications for children in Georgia if people who, you know, have abused children then go in and want to work in our child care centers or want to work at Children's Health Care or want to work in a lot of other places that are represented around this table. So obviously our interest is in child safety there, but it has to have the right safeguards in order to withstand the scrutiny.
And the child abuse registry also includes foster parents, correct?
Yes. Anyone who's the subject
which
of
is
an
right.
investigation.
Yeah, because that's always been a concern that we have always had, because of when families move from one county or region to the next, you can't always tell if they've had a substantiated child abuse history.
Well, and we have parents who specifically move across county lines to evade that for that very specific reason.
And this theoretically could help.
So, and it's particularly when there's sexual abuse involved, it's particularly troubling because very often those people are seeking out employment that puts them in direct contact with children. So if it's not prosecuted criminally, then our children, you know, really remain at risk.
Would this registry also be available, would it include the children to try to keep them safer? Because I know in the hospital, if we knew, I mean, these kids come to our emergency rooms, they come to our urgent care, and if we knew they were in DFACS custody, that would be very helpful for the workers, the healthcare workers that are taking care of them. And we're very accustomed to dealing with, you know, highly sensitive information. But I think you have schools and you have doctors and you have hospitals that see these kids routinely, yet there's no information that's passing where you can have more of a community trying to surround these kids and keep them safe, as opposed to, you know, it solely falls on one agency. And there are a lot of people that care a lot about these children. So if that could be another thing that with, you know, appropriate protections, that healthcare workers, and I think their teachers as well.
That's one of the issues that it was part of the challenge it was that there, in the statute previously, the prior statute, it specified entities that could have access to it. And the insinuation from the court's opinion is that it was maybe too broad. Or that, so either you need to narrow that group of people who could have access to it, or heighten the penalties for improper disclosure of confidential information. And so there's kind of a balance there.
And I know Bobby has the information to share with us, but was confidentiality addressed by the work that you've done? Have you looked into the because that's different than constitutional rights. Have you looked at confidentiality in conjunction with release of any of this information yet?
In terms of the actual registry?
Yes.
Only to note as far as what I just said, which is that the part of the challenge that the court was, and part that the court was dissatisfied with, was this, and it's kind of this balance between either there were too much allowance for public access, if you will, and or it wasn't coupled with significant enough penalties for improper disclosure. So either you can let those people have access, but make sure that they know that there's a severe consequence for improper disclosure, or you need to narrow the field of people who can have access.
Thank you, though.
And remember, all healthcare workers are subject to HIPAA, and so that's pretty significant in itself.
And some of that has changed over time since 1998 when the statute was struck down. So there are new considerations about a lot of these aspects.
I think the other thing that came out of the child fatality review precedent that a lot of us attended was that there may be some opportunities around legislation and protecting children even after they've died. Though, you know, looking at how we strengthen investigations. I know around SIDS deaths, there's some opportunities around autopsies. Will your subcommittee be looking at how we continue to make sure that we're not missing cases?
Well, we have to.
Okay.
Missing in the sense of the failure of not DFACS, but private parties who have caused death of a child and
Well, no,
outside DFACS. I mean.
Sometimes the autopsy's not done, even when there's some stuff that looks a little suspect. And so that would involve the GBI, but,
Using the law, the general statement, but using the law, if there's a mysterious cause of death, or doctor's not gonna sign off a certificate, it's gonna be an autopsy, you know.
but it,
Since-
with children, unfortunately, there can be unknown cause of death a little more frequently, it seems like, than with
And a
adults.
specific example that everyone's kind of hit on, Chairman, is the example of a child who might have a special need. They go home from the hospital, and they've got a medical need, so they're on a feeding tube, for example, and the parent lacks the motivation, skill, attention, wherewithal, whatever that is, to make sure that that child has a clean feeding tube all the time, and the child ultimately dies as a result of that. The coroner is gonna determine that to be a medical death and not do an autopsy.
Not a negligence stuff.
And from this, the sort of eyes of the child welfare community, that has hints of neglect in there.
Are there any other thoughts and comments for Representative Willard? Dwayne?
Yeah, I don't wanna be presumptuous, it's not about a value, it's about a value statement, anything about what's going on, but it's outside of the scope. But is there any, do you think there's any merit in us looking at the organizational structure or,
Yeah,
from an effectiveness standpoint? in
I
terms of
mentioned
function?
governance of the.
Function, I'm talking about internal to the department.
Okay.
The functionality of alignment and those kinds of things. Around executive level, accountability, responsibility, that would be a different layer. And it may be that way now, I'm just saying, I don't really know.
Well, Bobby, are you doing kind of an internal review of your structure as a part of this?
We will be. I have resisted the urge to do reorganization immediately because I wanted to understand exactly what we were dealing with before we do that. But that is something that we will consider as we get a fuller picture of exactly what is going on. I can tell you, just on the face of it, I look at the structure, for instance, of our state office and have a great deal of confusion about how we arrived at some of those. So I can assure you we'll be looking at that.
Would it be
Yes.
helpful to have any recommendations from this commission in that regard, Director Cagle, or do you feel like that's something that is best left to an agency to determine?
As a director, I prefer that be left to me.
That's what I'm asking.
Thank you for your honesty. Okay, well, we're gonna adjourn our meeting in just a moment. I did wanna tell you that October 7th, I hope is on everyone's calendar. I don't know if you've gotten the email. Has everybody gotten that email about October 7th? That's our next full committee meeting. And the meeting is here again?
And we'll do parking passes again.
And hopefully that worked well for everyone. Did anybody have any difficulties? Okay, so October 7th is on your calendar. Please get to your subcommittee meetings if you've not been able to. Because the next full committee meeting that we have, we will be having reports from your subcommittees on recommendations. So you've got a little less than a month to get a lot of work done. Any thoughts, comments before we adjourn the meeting? Well, thank you all for being here today, and we'll look forward to seeing you back on October the 7th.